I know I've talked to lots of you over the years, it seems. Sometimes when you know most of your audience, maybe that means you've been doing the job too long. But it is true. I'm very lucky. I get to spend a lot of my time doing open government work, exploring what other states are doing in terms of open records, what other states are doing in terms of open meetings. And what I'd love to talk to you about today, and also do some brainstorming about a bad bill that's coming, which hadn't been dropped yet, and maybe you guys can help me come up with some defenses against it, is just walk you through the legislative process, mostly what's happening this session and in prior sessions in connection with open records. Let me, before I begin, though, tell you that typically in the last few sessions, we really have had no activity on open meetings. And I'm operating on the assumption that this group, of course, knows what open meetings and open records are. I know some people at this table know more about the issues than me. But typically at the legislature, in the last few sessions, we've had no bills addressing the Open Meetings Act in Georgia. And I don't know whether that's a good or a bad thing, but be that as it may, all the activity in the last 5 or so sessions has revolved around open records, and we're going to look at this first handout in a minute, which is the exceptions to the Open Records Act, meaning what the government can withhold from us as practicing journalists or active or citizen activists. The last area, just to tell you what I do typically, and if you have questions in your reporting and when you're writing, is I deal with open records, open meetings, and camera access to courtroom. So a lot of the times I'll get calls from reporters or television reporters or both asking why the judge is throwing me out of the courtroom and what do I do. So our mission at the First Amendment Foundation, as most of you know, is simply access to the courtroom and then to public records, to public meetings. So anytime you've got a question, I'll do my best. What I've passed out for this first handout, I was hoping we could read some legislation together today that I could show you how the process works. You've got the current law in front of you. It's OCGA, which is Official Code of Georgia Annotated. The section is 50-18-72. You may not know the numbers to this, but what this is really is something worth knowing about. It is the exceptions to the Open Records Act, and I want to be clear on that. It gets twisted up, and lawyers love to twist things up. You've got in Georgia, in a preceding code section that's 2 sections earlier, 50-18-70 and 71, they talk about this idea of the general rule of openness. Public documents, all the agencies you guys cover, we all cover, we want information about general rule of openness in Georgia and in other states. So I typically advise folks that's where you start from. But this section that I've handed out to you, 2 code sections into the chapter or the title on open government, is in some ways a roadmap to what's really going on in the statute. It's entitled When Public Disclosure is Not Required. I typically think of it as what are the reasons that the government can withhold documents. And what I did today in an effort to try to acquaint you with the process is I took the statute. This is the current 2006 law. It's good through the end of the year. And you'll see, if you flip through it, certain handwritten notes, and those are notes that I wrote on it. So let's start, for example, with A1. That's the first exception in the Open Records Act to what can be withheld. Now, it's pretty standard. If a document is withheld or allowed to be shielded from disclosure by the federal government, our Georgia law, this is state law, says in Georgia that's the same thing. But why did I write it up? Last week, the folks in North DeKalb County dropped a bill. It's pending in the legislature, and I'm going to show it to you in a minute, that is trying to make the 2 changes that I've noted on this, on A1. The law today reads, specifically required by the federal government to be kept confidential. What these legislators wanted to say, and I can tell you why, is this very modest change. Some people would say it's modest. Some people would say it's disastrous. Mostly it's probably a modest one. They want to tinker with the language. But that's how it works. You've got your working law, your statute, piece of law that lawyers go into court, litigate, generate the cases involving. And every year, as you know, at the legislature, typically we get a lot of bad bills, some good bills, but it's the legislators dropping, and I'll pass around next, copies of what's pending. I've marked to your right there 2007 House Bill 49. It's actually House Bill 39. I made a mistake, but if you go through this entire code section, in the last 10 years, it's doubled in size. And if you go down to 4.1. Before I came to this job, while you guys started to report accident reports, motor vehicle accident reports, when you got into a car wreck, you could get your accident report. Just like today, you can get an arrest report or an incident report. Can't do it anymore. Anybody remember Clay Land, now a federal judge, Middle District of Georgia? He sponsored in 1999, see my year, 1999, Senate Bill 20, that was the name of the year. He wrote a bill which did pass in 1999, so it went into the law in 2000 that said, okay, only certain folks, only certain classes of folks could get their accident reports. So now, if I just want to go down and get an accident report, can't do it. As a journalist, as other people, I gotta sign a statement of need. So why I'm using that example and the others is just to show you how the process worked. That's a fairly recent change in 1999. That, for your information, was because the ambulance chasers, that was the big fear that year in 1999, that folks were going around, people were in the hospital, and lawyers were calling them and saying, I want your case. But that was the, shall we say, the reasoning behind 1999 Senate Bill 20 that's now become Code Section 501872 little a 4.1. If you keep looking through the law, and this is the whole current open records exception law, turn you something to more recent that a lot of people make fun of. Down at the bottom there, 10.1. It's on the third page in. This is one for folks who are at the AJC. Remember Tom Bennett, who retired in the last few years? He used to get very upset by this. Farm water measuring devices are exempt from public disclosure under the Open Records Act. It was 2004 Senate Bill 436. Now you may ask, why is this important? Who cares? It's not so much this bill, but if you look at the length of this statute, if you keep flipping through, you look at the different bills, which I've denoted on the right, you see it keeps growing. Every special interest group, every special lobbyist is now carving out yet another exemption to the Open Records Act. I'll turn your attention to the end of this packet. You'll notice it's pretty interesting. Look at the last few sessions. And I'm going to turn to what's known as subsection 17 under the law. 2004, House Bill 1358. I stood outside of some committee meeting talking to the sponsor of that legislation saying, I know we want to protect our minors, I know we want to protect children under 12, but why do we need another exception? Then look at number 18, which was passed in 2005, State Records of the Tollway Authority. All these really kind of silly, and of course the sponsors of the legislation would take issue with me calling these bills silly, but look how narrow they are, and look how we've doubled in size in the last decade, essentially, the number of exceptions, the number of classifications of documents that are not subject to disclosure. So it's worth noting. It's sort of, and I brought you examples of letters that I write to the governor asking him to veto this bad legislation. I typically call it a systematic undermining of the Open Records Act, a systematic undermining of our general principle of openness. If we brainstormed here today, we could come up with another specific exemption to increase the number of exemptions and to whittle away even more, if you will, at disclosure. So again, the bill numbers are not important. I have, though, denoted them there for you simply to show you in recent years, typically at the end, you have the 2004, the 2005, 2006 statutes, but that's how the process works. You've got your current law. Every year you get a couple of bills dropped, and they change the law. What I'm going to pass out next, though, are the two things that are pending today. They were dropped in the last month, that are going to change the, are efforts to change the law. The first one I brought your attention to already. It's A1. The other one is an addition, and if you note to the right, I denoted 2007 House Bill 101. it would go after the code section 10.1, and I actually have not studied it enough yet. But I want you to see what legislation looks like, and I want you to see how it fits into the statute and how the process works. Any questions while I'm doing this? It's kind of dry material, so I don't know how to make it any more interesting, but it's got to be done. So. How does Georgia compare with other states? Topically, our law looks great. Here's what we lack in Georgia, and some of you may have heard me say this. We don't have any effective remedies in Georgia. You're looking at your remedy, or the AG's office is the remedy. If you don't want to sue, and typically your media outlets are the only ones who are going to sue, but me, as a citizen, I don't have a remedy. So we're okay. We've got a 3-day business day response time for open records requests. Some states have 10 days. Some states have no time amount. So we're okay. It's what our big weakness in Georgia is the lack of remedies other than a civil suit in the Superior Court of where the problem occurs. So I'd say a couple of the national think tanks do these surveys. We're always sort of in the middle slightly to lower. But okay. Anyway, take a look at, you've got House Bill 39. That's what a piece of that's what a bill looks like. They're typically on legal-sized paper, 8.5 by 14. A lot of legislators complain when they get down to committee meetings. They've never seen them before. Folks are doing ambush tactics and passing them out at the. But this is this first page, 2007 House Bill 39 was. If anybody remembers the Peachtree DeKalb Airport Authority litigation by Peachtree DeKalb Airport in North DeKalb County, or not North DeKalb, DeKalb County, this bill came out of that dispute and an attempt. One interpretation of this bill is that it would clear up the ambiguity in the law. If specifically required by the government, what does that mean to be closed as opposed to a statute or regulation to keep something closed? I will be saying in the paper tomorrow, if my quote makes it in, ostensibly the intent of the sponsors was for uniformity in the law, but the public should be concerned to the extent that this change in the law would expand the ability for government to withhold documents. Very tricky, as you know. You read something like this, it sounds good. How is it going to turn out? So I'm always nervous, but this one, to the extent a bill is as innocuous as possible, it seems okay. What's the difference between required by the federal government to be kept confidential as opposed to by statute or regulation? Again, the sponsors say, a couple of the folks in the AG's office say that that means if it's closed under federal regulation or statute, it's closed under Georgia law, as opposed to when a federal employee says something should be closed or not, which was the subject matter of the dispute of the case that was litigated in about 2 years ago. Okay, your second bill, the only other open records bill that currently is pending right now, although I'll tell you what's coming, is this House Bill 101. It was dropped a couple of weeks ago. I have not studied it sufficiently. Let me tell you where it would go, and you could guess, you could tell it. The bill tells you right in the language of the proposed legislation where it would go. It would go on, let's see, I'll tell you what page of the statute. It would go the top of page 4 of your statute, and I wrote a little arrow on your statute saying where it would go in. I don't know enough about this bill yet to know. I mean, I typically, if you listen to what I say typically down at committee meetings when I'm trying not to giggle or something, I typically say public access is the only thing we should care about. No exceptions are good. So that's always my first starting point, and I say the same thing all the time. I don't know enough yet about this bill, but it's a good example when you're looking at open records legislation to see how it works. The other point I'd make about this one is, it's hard to make this issue a sexy issue because who really cares about House Bill 101? The very narrow group of folks that are the proponents, but do you and I care? Am I going to go leave my very lucrative law practice that I'm litigating to earn my money to go down and testify against this bill? Why do I care? I mean, that's what makes me nervous about these specific bills. You're getting lobbying groups, specific interests, getting legislation drafted for them at their behest. It's passing, and again, it goes back to my theme of a systematic sort of whittling away at our general principles of openness.
there have been a couple of issues very recently that speak directly to this legislation. It would prevent journalists from getting information about a foodborne illness that may have originated in Georgia, say spinach, or it would prevent release of information about a cow suspected of having that. Just from what it looks to me.
So a good one for me to leave the lucrative practice of law and get down there and testify against.
Well, if you can't, the press cannot let you know if we have a problem with food coming out.
You're not going to be able to identify the source. You're not going to be able to find out the source.
But let me point out. Let me point out though a good a point from what you're both saying. I can tell you that everybody says I'm the expert. I don't know what it means. Just like I'm telling you, go back to House Bill 39. It looks fairly easy on its face. It looks like it's just a cleanup of the law. It looks like it's a cleanup of the statutes. But you know, you never know, and that's why these tinkering. These aspects where we tinker with the language. I'm most upset, I guess my first thing I get the most upset about is when I see a litany of bills dropped to create no exceptions. So I got a growing number of exceptions. You know, when I started, you know, you think maybe there weren't so many. We used to pride ourselves in Georgia that we only had a handful of exceptions, while Florida had hundreds of exceptions. Well, we seem to be growing, as evidenced by the very narrow exceptions that we're attaching in years 2, 3, 4. So I guess why I bring that up is I don't know. You know, I'm going to study it and I'm going to look at it and we'll put together some good testimony. Typically what happens down at the legislature for folks who don't go is they'll have a committee hearing on these bills, and then I'll get notified and I'll go down there. I'll prepare some remarks if I don't know about something. Like, for example, this House Bill 39 was actually dropped last year in 2006. It didn't pass, and I never understood why. So in preparation for my testimony, I called the litigators on the Peachtree DeKalb Airport case, and I said, look, what do you think of this change? Would it have hurt your case? Would it have helped you? Is it good? Is it bad? I called the assistant AG who was involved in the case. So I'll do the same thing, but these bills come up for the most part in committees where you get a chance to make your case, and I've often called some of you guys to come down with me and to I'll put up evidence, I'll testify, and I'll ask working journalists and citizen activists as well. There was a great bill last year. I think I copied it in connection with the next handout I'm going to send out that would have strengthened remedies. And I was just so excited. I was running around the halls trying to build a coalition to strengthen the remedies of the Open Records Act. Didn't pass. To my, I was disappointed though, because at the last hour, as many of you know, things are a moving target and they change. And somebody slid into my remedies bill. It wasn't my remedies bill, but I took. I was very enthusiastic about it. Slid in a provision to allow agencies to require open records requests to be in writing, which is something that I'm unhappy about for obvious reasons, and we could talk about that. So these bills start out with something quite simple, like 39, and I don't know whether 101 is simple, but you guys make good questions, and we'll figure out what it means. And they often take on their own form, their own shape. One question, though, one thing that this, I think, jogs or is worth exploring, why don't we, as the press, citizen activists, public interest folks, why don't we sponsor affirmative legislation? You'll notice, I suspect, since many of you or all of us have been around or reporting, we typically are on the defensive. The last time we really had a positive overhaul to the Open Records Act was 1999, when Governor Barnes was in office, and he really, I will say, revamped the Open Records Act and made some changes to the Open Meetings Act. Since then, there was a bill last year called Senate Bill 153 that made the private university campus police departments such as Emory, Oglethorpe, Mercer, their police departments subject to the Open Records Act. But don't you notice that typically we tend to be fighting off bad bills, and we're always scrambling around? Most of you probably know about 2005's House Bill 218, the one that was famous, whatever that may mean, for it would have shielded anything any legislator would have called a program of economic development. I used to say, what does that mean? And that got a lot of press. But notice that we're all on the defensive, and that's something I don't know how to change. We often say that the climate is hostile to good open records bills or open meetings bills. I think that's probably true, but it seems to me there's got to be a way with great press groups like the Press Club, Press Association, great public interest groups, League of Women Voters, Common Cause. It's just something to think about, and I think things like Sunshine Week, which is a national effort to promote awareness in sunshine, is at least a movement in that direction. Let me keep...
Holly,
yeah.
who among our elected officials at the state level do you regard as champions of open government?
And I'm hesitating not because there's no one. I want to be very clear, and I spoke to some people about this. You know, open government's not a partisan issue. Everybody views it as a Democratic issue, and the Democrats have taken it up, and I don't know if anybody recalls there was a several constitutional amendments dropped, but that didn't pass in the last session. That would have made any additional exemptions to our long list, requiring a larger majority of the General Assembly to pass. There are a few champions. They have lately, and I won't give names, and I won't say because you all are journalists, and that would really mess me up. But I'll get some names to you. There are a few folks. Unfortunately, anyway, you got a lot of folks who pay lip service to open records and open meetings, and then you've got a lot of folks down there who are openly hostile to it and will be polite to me, but basically say they don't have an interest in open records. And I always try to point out, look, even if you don't like the press, and we were talking about this before the program started, how about me, the public activist, the public, your constituency? Don't like the press, fine. But it's not about the press. It's really about you, your vote, your constituency.
Do you think the AG's office has been suitably aggressive?
That's and this is scary when I remember the number of the bill that passed in 1998. It was House Bill 1549, which I did not copy the statute for you. It gave the Attorney General, state top civil law enforcement officer of the state of Georgia, the ability to both prosecute criminally and intervene civilly in open records disputes. First of all, let me tell you why that happened, and then I'll tell you what I think of the program. Before the AG got involved, the Attorney General's office, who was going to look into these disputes? If you were in a small rural county in Georgia, your local DA wasn't going to knock on the door of the county commissioner next door and say, hey, you're messing up on your Open Meetings Act. You needed somebody else, and that's how the idea, it was a sort of an idea that was modeled after Florida and Texas, that we get somebody in a state agency the ability to look over state or county and municipal agencies. The rub, of course, is that the Attorney General's office represents the state agencies, and yet the Attorney General's office is charged with monitoring violations by state agencies as well as county and municipal. But another topic. How do I think the AG is doing? They have what they call a mediation program. You don't get a document you want, or you don't get in a meeting you want, you write them a letter. Their first response isn't to say, yeah, you're right, great. They'll immediately send a letter to the other agency, the allegedly offending agency, and ask for their side. They say, and I just did a panel on Sunday with their open government coordinator, they have a high success rate. I don't know, I hadn't looked at the statistics. As you know, they intervened in litigation, which they can do in the high-profile Super Bowl case, NASCAR case, to open records. Their problem is that they're not funded in that office. They got charged with or so they say, they got that new jurisdiction, that new task, the new demands, and they've got one guy doing it, or a team doing it, but he's doing it in addition to anything else. I hear complaints that things aren't getting turned around. Has anybody here utilized the AG's office to mediate an open records or meetings dispute?
I just want to ask you, what is the main complaint from the politicians why they don't get over this? But I can understand in a situation with Washington where you might be, hurt the entire country by letting somebody know something. But as far as what you're talking about, what is the main complaint from the politicians? Why are they trying to stop?
Anybody else want to take a stab at an answer, and then I'll jump in.
It's going to harm our trying to convince Kia to move to West Point or convince Chrysler to move to Fuller. I mean, it's not their common, story that it's going to harm it.
Yeah, in connection with that specific bill, that's absolutely right. If we don't have this bill, we're going to lose all this industry and all this stuff.
It seemed like one of the things that I noticed on some of these amendments was a privacy issue. Can you see who went through the toll booth at such and such time? Can you get, social security numbers, home addresses? And there was something just 2 or 3 weeks ago where there were so many records that gave everyone's information that people who wanted to get false identities could go and get all this information, social security numbers, birth dates, mother's maiden name, all these things that are usually filters that we use to help protect our identity were all in, these forms that were open to the public.
Well, you make an interesting point, because you'll notice that in our state Homeland Security Act passed. Most states passed theirs in 2002. We passed ours in Georgia in 2003. That was a response to.
You said you have a hard time trying to figure out what's good. Is it a disaster or is it a moderate?
We were. I was on this panel with what's called the Open Government Coordinator. On Saturday, the issue came up, and he was saying to me, typically we don't really get involved. I think there's a reluctance on to let the legislative branch do what it will, but I don't know the reasoning behind it, but they have not typically, and I've asked them to come testify from time to time, and I'm not interested.
Well, following up on Maria's question,
This way.
has there been any documented case or cases of someone using open records with criminal intent for identity theft?
Is there a documented issue? I thought you were going to ask a different question. One of the complaints I get from the legislators is, what do I do with the person who files 80,000 open records requests to my one-person department? And they always say, I want to put a cap on open records requests. And I said, now, while I'm alive, you're not going to do that. No, I don't. There was some piece, an ABC piece some time ago about I'm sure some of you saw it, some inmate from who was tracking his victims' movements from prison and by way of the internet and Social Security, and that was a big open records issue. But I don't know. I'm sure, I haven't done the research, but I'm sure there may be. But I mean, identity theft as a policy issue, as you point out, is a hard one for the legislators not to rally around, on the privacy issues as well. I'm passing you out this last code section. It's the last piece of law I'll ask you to take a look at for another reason. And then I have attached a bill that was dropped last year that did not pass, that would, it's at the very end, and it would fit right into where I marked it on the statute. There was a bill last year, I referenced it earlier, that would require would allow an agency, a public agency, would allow your government, my government, to require open records requests to be in writing. And that's something that I have testified against every year, some for obvious reasons, some for policy reasons, some for whatever reasons. On Tuesday at a committee hearing downtown, the chairman of the Judiciary Committee, who hears these kind of bills, said that this bill is going to be coming. A representative, I can't recall where he's from, Mark Hatfield, is drawing up the legislation. It's going to be very similar to what's at the back here. That's labeled 1071. And I, of course, will fight that legislation, but I was hoping that this group, we could have a working sort of minute or two brainstorm session about how you convince a group of hostile legislators that while an open records request, putting it in writing is a good idea, and I encourage all my clients and all my callers and all my inquirers to do it for policy reasons, it's a good idea to create a record, a paper trail. Well, first of all, correct me if I'm wrong. Perhaps it's okay. Maybe it's okay to have a.
How else do you do it? By phone?
Right now, the law in Georgia says that I can walk right up to my police statement and say, give me this incident report, give me this arrest record, and I'd like to preserve that right, unless you, as folks who use the open records request more than me, tell me I'm wrong. I have spent a lot of time trying to argue while I'm standing up about, well, some people can't write, so wouldn't that disenfranchise them from using the open records request? And then the legislators will say, Holly, but the clerk will help them. And I'll say, so-and-so, the clerk will not help them. And so it degenerates a bit. I guess my questions for this group are, is it a good thing or a bad thing to wipe out the existing law for the past 3 decades or so that open records requests can be verbal? And if it is a bad idea or a good idea or bad idea, how can we all work together to make some arguments appealing to the legislators who would want to wipe it out? I'll go to you, and then to you.
Well, if you submit something in writing to a government agency, presumably that would then become itself a public record.
That's correct.
And so if I'm a rape victim and I want to find out when my assailant gets out of prison, for example, and I go to the Department of Corrections and I file that with someone, presumably he could then access that record and possibly I'm required to give my address or I'm required to give some sort of identification, or at the very least he sees what day that I came in and possibly deduces that I might live in the area, or, I mean, it's some sort of identifying information.
So if the requirement of writing required you to identify yourself, or there's some case law and some attorney general's opinions in the law that says you can't ask someone why they're making an open records request and who they are, but it does seem if we're going to have a writing requirement, someone's going to probably ask for your name. So that's a good point.
I mean, just on her, couldn't they get that from the incident report, or?
Although redactions, of course, but yeah, sure.
Well, I guess the other thing too is, I mean, I have arguments with all the things oral. Asking for something oral is nice because if you're on a deadline and things like that, or if you have a relationship with pianos like a lot of reporters do. The other thing that I like about writing is when you're in constant arguments with a certain agency, you have in writing, and you have communication, because I've caught agencies and lies before where they said one thing, and, you know, we had on written paper and other. So the one thing that I don't like about doing a oral request is they sometimes either misunderstand what you're asking, or they construe it, or they say you never asked it. So I think that at least in writing you have something physical when you try to go through the appeals and look at change it up.
Although, and that's a good point as well, although even though we allow verbal requests, you can always put it in writing. There's no requirement that you can't do more. Yeah.
I think that it goes to a fundamental switch in the idea that the records are open and they are the people's records, and the presumption should be that you're going to hand them over across the desk. And when we start imposing, for us as journalists, it's no big deal for us to put in writing that you're going to be that info. But for the average Joe who walks up to the clerk's office, they shouldn't have to know the mechanics of this law. There should be the presumption that the clerk is going to hand them the records.
You know,
And by formalizing the writing, I think it begins the slope of then, you know, you must designate why or how you're going to use this.
Does it have to be notarized?
and I'll go to you. I'll tell you that I have tried to make that argument not as artfully as you. I have said it's yet another impediment. Why are you trying to keep this? It's just another barrier. And I tried to build that image, not very successfully, but it hadn't passed till now. I'm sorry.
It's almost like a protest if someone uses bad grammar. Are they more likely to get turned out? If they don't use the right term of art, are the lawmakers or the custodians of the record going to seize upon that and say, that's not exactly what you asked for? I think an oral request allows a broader interpretation, and if we get more immigrants, they need to be able to know that they can access their records without putting it down. I don't think the lawmakers are going to buy an immigration-friendly bill.
It's an interesting point. You know, I suspect, if my memory is right, this bill last year, the one at the end of that handout, was drafted, this language about an agency. The written policy was drafted by the legislator who's going any day now to drop this new one. And it had interesting language. It said an agency may implement its a written policy, which struck me as interesting. It allowed the agency, the public agency itself, to make the decision, which, of course, if you're in a local community, that's sort of that more of those control issues of sorts that we're sort of getting at. Someone's going to say something.
I mean, even though the law doesn't require it, my experience is that they just not going to budge until, because you can't.
And
Experiences lately have been pretty frustrating. You can't make them do it.
Well, I think you're right, and I will tell you that if you call my office, and I'll tell you, go ahead and put it in writing, and if I'm testifying or I'm on the stand, if you will, and someone asks my opinion, I'm going to say, yeah, it's a great idea, but we still shouldn't have it in the law, which is a very hard argument to make there and then there.
My thought was that it doesn't really matter if they're inclined to give you the record, and you can just ask for it. Even something as simple as a school board agenda. Can we have the school board agenda? Well, put it in writing. I'll get back to you in 3 days. Or here it is right here. So it's either they're going to do right or not. Well, it's in writing.
Yeah, I think that's true. I'm sorry.
About one problem with putting it in writing or requiring it that it be in writing is if there is an agency trying to cover something up, it just makes it that much easier to say, well, you didn't ask for specifically this document, so we gave you that one. So you have to be even more specific with exactly what you want, whereas before, if you could just say, let me see this file or this, subject, you have a much better chance to find what you're looking for. The other thing is, if they say put it in writing and 3 days later we'll see if we can find it, by that time they can get rid of it.
I mean, all our points there.
What is their stated preference for having? What would be the pro for having it in writing?
Sort of the flip arguments of what we're saying, variations on the theme, memorialization. If you have a difficult requester, everybody knows when it was received. Everybody knows when the 3 days begins to run. Everybody knows.
Easier for the clerks and the guardians of the public.
Yeah, that's a good way to put it, though. Building on your argument, I could say because I often try to say it, and sometimes you get through. Who are these laws for? Not for you, for us. And so that's good. That's good. Somebody else saying that's good though.
Well, you might also be able to make the argument that, number one, they could keep those records on their own anyway. They can have a log, they probably do. But we are on a slope here of building more costly bureaucracy anyway. You then have to set up filing systems, you have to have people who are monitoring this. It's making it more cumbersome.
Yeah,
They take the 25 cents regardless of how much it costs. They take the 3 days to get the benefit regardless of how long it takes. So this is just one more.
It's so fascinating. There is a case on the books. It's not that old. It's McFrugal Car Rental. I love the name versus Gar, and it's from the 1982 or 6. I don't recall. It really talks about that issue. Really, that if it's right there and you walk in for it, give the person the record. They just want to inspect it as opposed to copies, let them in. And it's such great artful language by the Supreme Court, so inconsistent with what folks who are using the Open Records Act on a daily basis are struggling with. But, yeah, I'm sorry.
Yeah, my concern is the beginning of a slippery slope, the added restrictions. And does that mean even if an agency is inclined to give you documents without any friction, are they going to feel like, oh, well, we have to get it in writing before? So, I think the end result would be that the access to government records would end up being a lot tougher to get and cumbersome. And I know for me, I don't get involved in a lot of the huge FOI stuff, but it's great to be able to say, I can file an FOI request. But, we're on the phone. Just let me know if I can come by your office and pick it up. So I don't have to, and then, let's say 9 times out of 10, that works.
Yeah.
Do they consider an email in writing?
Yeah. Well, let me just say this. I think last year said the written request may be delivered to the agency by mail, fax, courier, email, or other delivery.
So in other words, if I have the wherewithal and a computer to send an email, my request goes instantaneously. If I do not have the wherewithal or the access to a computer and I've got to get myself to a fax machine or post it in the mail, my request could be delayed by, who knows how long. So as it is now, we're sort of all on an even playing field. Anybody can call up and say, I want this record. But if
That's
by
a good
introducing
point.
this bill, you sort of have a strata of different methods by which the record can be requested, and so you sort of essentially put people on different timetables.
Yeah.
I think the problem with this bill is that it just assumes an adversarial relationship between journalists and the agencies and the community we're serving. And that's usually not the case. And for example, if we do have a case of food poisoning, there's only so many government investigators who can look into the chain right quickly, and there's about 100 journalists who would love to look a little bit further. And that's a case where days could make a difference.
It often makes me mad when I'm looking at a big public issue, and then all of a sudden, law enforcement wants media to be its best friend. After we're fighting all these impediments. A very good point. I could talk about this perhaps so much. It shows you what lack of a life I have. I'm going to hand out just an example of. I couldn't find what I tried to get vetoed last year, but I thought it'd be interesting to see. I write the governor every year when what I consider a bad bill passes, telling him why I think he should veto it. Because the process is after it passes through both chambers of the House, of course, the governor either has to sign the bill into law. So you'll see that all these letters start out the same, where this agency charged with monitoring the public's access to information, and I try to point out, and that's where that language should have conclude my remarks on the theme. Again, every time you look at one of these exceptions, they don't look so badly individually. They just seem, it doesn't affect much, doesn't really, but when you look at the sort of systemic undermining of the Open Records Act and how the exceptions are just more than quadrupling. They just keep going up and going up. But anyway, you'll see that's sort of the theme of my letters, and I wait until the session ends, as most of you know, last week of March 31st every year. So in April, I always see what's passed, and then I write my little letters saying, please don't sign it. Yeah, they always write me back and say, thanks for your letter. And they always sign it.
More letter?
Yeah, of course.
How much effect does this really have on them? Or they just pretty well have their minds made up and they just toss it trash and say we appreciate it?
Yeah, if it passes both chambers, the governor's going to sign it. I feel that someone's got to put in writing somewhere that not all of us are so happy with the Open Records Act disappearing. One question, though, you all have raised for me. I know how our laws stack up today with the other states. I don't know how. I think the other states are struggling with the same kind of. Every now and then I'm on the state listserv with my counterparts doing, and I see the same stuff coming up. But that's worth seeing what the other states are doing. Florida has the greatest law in the whole wide world. If the legislature does not renew an exception, is a sunset provision, so it expires. So I'm sure they're always running around hoping that some of these exceptions will just fall off because they forget to renew them. But anyway, other questions I can answer about anything pertaining to open government if I know it.
When is Sunshine Week?
March 15th it usually is, James Madison's birthday. I think it's March 15th or 17th that week. And we'll figure out something to do. The AJC and some of the other publications fuss about it, and we'll do something.
Mike Bowers has always been a very
We were just
intriguing
talking about it.
person because you probably can find a more conservative Republican, but on this issue, he is so passionate for open records and open government, and it seems that I don't know if he's available to help do some of that due diligence work or represent it, but instead of Hollie Manheimer, maybe some members of the legislature would listen
Hear
to
him more.
Yeah,
That's a good thought. We've been sort of kicking around putting him on the board of directors, but to have him actually testify against some of these bills is a brilliant idea.
I think
I bet he'd do it.
it's their language.
Yeah, and they know him.
Yeah.
So,
I was going to ask you, number 8 applies to the legislative
The legislature has exempted itself, and it's actually case law. There's a case from the 70s called, doesn't matter the name, Coggin versus Davey. But in my experiences, they specifically have exempted themselves, and I think it's the utmost hypocrisy that is ever, one of the most utmost hypocrisies. So I hadn't really, I hadn't made the effort to push them, although I was relaying a story about once getting into a fight with one of the governor's flunkies, not this governor, another governor, about saying the governor's office ought to be subject to the open record legislative branch, but those branches typically have exempted themselves.
And there's sometimes you get around it, I just, sometimes they're okay with it, and they're considered open,
I'll keep thinking about that one.
Holly, if there was one exception that you could strike down, what would it be?
It's funny, and I actually do have one, and I forgot if anybody does education work in law enforcement. These are my little books that I wrote, so I brought a couple copies. I have an issue with 4.1, the pending investigation exception. I'll tell you a little story, and then I'll keep quiet. I wrote this book with Georgia Bureau of Investigation, Sheriff's Association, Chiefs of Police. And I got more of those if folks want them. My vision was 4.1, which says law enforcement will not release records while an investigation is pending. My vision, shows you how naive I was that it would be the whole book. The whole book trying to explore what is an investigation, a law enforcement investigation infinite, when does it close, and law enforcement, the compromise was just this one paragraph on what a pending investigation means. So I think the most troublesome and the most broadly abused, and those of you who report on law enforcement would maybe agree with me, the pending investigation exception under Georgia law to withhold documents while a criminal law enforcement investigation is pending is probably my least favorite, because I have no good way. I cite the case law, I try to talk to folks, I wave my book around. It's still hard to get documents. So that's probably my least favorite.
We had a situation right now where we're trying to get information about a homicide, and they can't tell us where it happened because it's under investigation.
Right, it's pending. And it might be pending for 20 years. And, I once gave some ridiculous comment, post-habeas appeals in 30 years in the post-Supreme Court, and they gave me a blank stare.
How do you know somebody died?
I don't know, but the guy got shot on Main Street, but they can't say that because it's pending.
I'm very intrigued about getting into a proactive mode rather than a defensive mode. And even the press club, I think every year we talk about this program is what legislation is coming up that we need to react to, as opposed to what kind of legislation can we look for allies in the legislature, and what would we want legislation to say, do, change. I mean, I like the idea of sunsetting all the exceptions.
We would have an incredibly powerful coalition if the media and the public interest groups all lined up together and could come to consensus on something like sunset laws, something like remedies. We could, my vision, although some experts disagree with me, if we could get attorney's fees, mandatory attorney's fees for prevailing parties, all of a sudden the little solo practitioners would say, yeah, I'll take your open records case because we'll win, I'll get my fees. All of a sudden you'd start the ball rolling and we'd have a more aggressive statute. But I would love to work with the press club and others and maybe be part of some committee or effort so we could at least think about that. And even if the climate is generally not right, if we can find some allies down there, yeah.
One nice change maybe for us as journalists, recently Jane Kidd just got elected chairman of the Democratic Party of Georgia, and she's got a background in journalism, went to UGA journalism school, and was working with the journalism school prior to going into public service. But I think she would be probably very interested in rallying the Democratic troops around more journalism-friendly laws.
And I think that's wonderful. One of the things, and I'll be careful on saying it, the Democrats have been interested in a lot of these issues. I would like her to work with her and somebody of comparable note on the Republican side, because I think the key for affirmative legislation is the bipartisan effort. But that's good to know, and I didn't know that.
Holly, do you think it is helpful or example I have is we had a little brief item in the entertainment section about Usher's speeding ticket up in Barrow County. And there was like a throwaway line at the end of this little paragraph saying, court officials declined to release a copy of the ticket because it had personal information about Usher. And I just thought, I cannot believe I just read that sentence in my newspaper. And I mean, should we have like gone marched up to Barrow County and said, we want that ticket, or would that potentially tip somebody off like, oh, we need to maybe have an exemption for hip hop stars who get busted speeding? Do you think it's harmful or helpful or?
I'm not sure, and I'll tell you that when I started doing this work, I used to say the press had one powerful tool that the public didn't have, the ability to write a story and make the closure the story. But then I know that journalists, when they have different beats, you're going back to the same public officials who just then really shut down even more when they realize they're the subject of the story. So I think it can work both ways. I'm torn on that one. I think it's a good point. Thank you all. I enjoyed it. I hope it was helpful.
Hollie, thank you.
So Ed, you get that whole group together, work with all the public interests.
Again, anyone who would like to work with us on the Trust Fund First Amendment Committee, we'd love to have you. Drop me a line, your card, email.
Does Trust Fund have a legislative affairs committee?
Not specific.
I need to join.